Hello, my name is Jacqueline Minor. I'm the Director responsible for consumer policy in DG Health and Consumers at the European Commission, and I'm here to talk about the recently adopted proposals for alternative dispute resolution and online dispute resolution. On the 29th of November, the Commission made two proposals, one for a directive concerning alternative dispute resolution and one for a regulation on online dispute resolution. Why did we choose to make these proposals? First, because we know that consumers throughout Europe frequently encounter problems with goods and services that they buy from traders. Every year, about 1 in 5 consumers reports having such a problem. And the first thing they do, the first thing we would all naturally do, is to go back to the trader and complain. And in many instances, probably just over half of all cases, that resolves the problem. But if it doesn't resolve the problem, the consumer is then left with a choice. Either they take the business to court, or they give up and accept the loss or complaint. This is probably quite a rational decision on the part of the consumer, because the cost of pursuing court action would be disproportionate to the value of their claim. However, when you add up, when you accumulate all of those unpursued disputes, unresolved disputes, obviously the loss to the European consumer is quite considerable. And it's also, in our view, a loss to European business, partly because a dissatisfied customer is unlikely to come back, partly because the business is failing to take account of feedback which could help them improve their offer of goods or services or after-sales service, and partly because the money which consumers fail to recover from businesses when they have a legitimate complaint could then be reused to purchase goods and services from the best performing traders. So what is the situation with alternative dispute resolution in Europe? It's already present, more in some member states than in others, and all our research shows that where it exists, it is of benefit to consumers. But there are a number of problems. The first is geographical and sectoral coverage. There is not full coverage in all member states. There is not full coverage of all sectors. Some sectors are pretty well provided for, partly because in some instances other pieces of European legislation require member states to establish alternative dispute resolution schemes, such as in energy, for example. But there are some member states and some sectors where the provision is missing. Secondly, there is a variation in quality. The Commission has adopted in the past 2 recommendations laying down some principles with which all ADR schemes should comply, but these recommendations are not binding and they're not always followed by ADR schemes. And thirdly, there's a problem of consumer awareness. Even where schemes do exist, they're not always well known to consumers. They don't know where to go to take their dispute to ADR. First of all, the directive. It has a very simple objective. For us, any consumer who has a dispute with a trader arising out of a sale of goods or services should be able to go to an alternative dispute resolution entity with their complaint or dispute. So the first principle of the directive is to say that member states should put in place ADR schemes enabling all consumers, whatever the nature of their purchase, whether it's food, whether it's electronic goods, whether it's a service, and wherever they do this, whether they do it online or whether they do it in their local high street, can take their dispute with the trader to an ADR entity. Then the directive lays down rules as to the quality of ADR bodies. This is something that we already had, as I said, in the recommendations, but by putting them in a directive, they become legally binding. So we have rules on quality, on impartiality and effectiveness, on fairness, on the way in which the schemes operate. So for example, if you have an ADR scheme which uses a panel, then ideally the panel should be equally balanced between representatives of consumers and representatives of business. Then we insist upon expertise, so we ask that the real people, the human beings involved in alternative dispute resolution should have appropriate experience or training for their role. And finally, the directive also contains provisions on transparency and monitoring. So ADR schemes, ADR bodies will have to publish information about how quickly they resolve disputes, how many disputes they've dealt with, what the outcome of those disputes was. And they will be monitored by national authorities to ensure that they comply with the quality principles and that they meet all the other rules laid down in the directive. Then the problem of awareness. We address this by saying that businesses, traders, should put on their commercial documents, their bills, till receipts, on their websites, the details of the ADR scheme which covers them. So consumers should know from their very first contact with a trader that if they can't resolve a dispute with the trader directly, then there is a further alternative to which they can turn. So that's essentially the ADR proposal. That's a directive, and so it imposes obligations upon the member states, which after its adoption they will have a certain time to put in place. For ODR, we've made a proposal for a regulation, and here we are going to build on the existence of ADR schemes in the member states. So what we will put in place is a platform which bolts on top of the existing or to be created ADR schemes in the member states. The online dispute resolution regulation will apply to purchases of goods or services via the net and cross-border only. So this proposal is very much part of the digital agenda for Europe. It's very much part of making the retail single market, the online single market, work better for consumers. And we hope as well for businesses, because we know that one of the things that puts both consumers off buying from a website in another country and also discourages traders from offering their goods to consumers in another European country is the fear of becoming entangled in a judicial system with which they're unfamiliar. So we hope this will encourage both traders and consumers to overcome their reluctance to buy or sell cross-border. The Commission will put into place an IT platform which will enable consumers or traders to file details of the dispute they have with someone in another member state, and the ODR platform will then address the dispute to the competent ADR body. So it will act as a kind of clearinghouse. And then as soon as the parties agreed to having their dispute handled by the ADR system in question, the remainder of the procedure takes place entirely online. Of course, at either end, there will be real people. The consumer is a real person, the trader is composed of real people, and the ADR entity will be composed of real people resolving the dispute. But everything takes place via uploaded details to the web. We also have provided that the platform can be supported by experts in the member states. We think, for example, those experts could usefully come from, some of those experts anyway, could usefully come from the European consumer centres, who already have expertise in dealing with cross-border problems, who know about ADR from their existing role, and they might help to iron out any difficulties in communication or maybe different expectations because of the different backgrounds of the consumer and the trader. As I've said, these proposals were made on the 29th of November. They're now to be discussed by the Council and the European Parliament. The first meeting of experts in the European Council, national experts from the Member States, has already taken place. And we know that the Danish presidency of the Council, which takes office in January, intends to work very intensively on these proposals. In the European Parliament, we'll be presenting them to the Internal Market and Consumer Affairs Committee on the 20th of December, and we hope that there are two rapporteurs, Mr. Grech, who is a Maltese MEP for the ADR proposal, Mrs. Thun, who is a Polish MEP for the ODR regulation. We hope the rapporteurs will be able to see the work through in the first half of next year. Once the proposals have been adopted, and the aim is to have them agreed in the course of 2012, there'll be a period of transposition, implementation for the directive, and it's really only when that period of implementation comes to an end that the platform can go live. Of course, we in the Commission will be preparing the launch of the platform at the same time as the Member States are transposing the directive. That's it. Thank you very much.